These amendments, when fully implemented, will provide investment managers and sponsors of private equity, venture capital, real estate, infrastructure, and credit funds an Irish fit-for-purpose tax transparent investment vehicle, comparable to the Delaware Limited Partnership, a Cayman Islands Exempted Limited Partnership, and a Luxembourg Special Limited Partnership. My name is John Hunt, and I'm a partner at the international law firm of Sullivan and Worcester. It is my pleasure to moderate this panel comprising David Naughton of LK Shields, Brian Murphy of Grant Thornton, Michael Humphreys of Davy, and Philip Dempsey of SANNE. Our biographies and contact information are at the end of the accompanying presentation. Over the next 45 minutes or so, we are going to give you our initial observations of the new Investment Limited Partnership, or ILP. Much of this presentation will address legal and regulatory matters. However, we also will include our observations on tax, fund distribution, and depository and fund administration matters, and then what we will be following in the coming weeks. After the Irish Central Bank finalizes rules relating to the new legislation, we anticipate having another webinar to examine the legislation in more detail. We will provide information to you as we get closer to that time. Of course, if you have any questions before then, please feel free to reach out to any of us. Our contact information, again, is at the end of the accompanying presentation. Before launching into questions for my co-panelists, I just wanted to share two observations I have as a US lawyer. First, the ILP, as the name implies, only applies to funds, alternative investment funds, or commonly referred to as AIFs, and not, for example, operating companies. This is very different from the Delaware Limited Partnership Act, which is not specific to the type of entity that may be formed as a limited partnership. The second, as we will discuss, the law includes what we in the US would call regulatory matters. In other words, the Irish law goes beyond issues such as formation, governance, liability, and dissolution, which are essentially the core of the Delaware Limited Partnership statute. For non-Irish lawyers considering this type of vehicle, I think it would be helpful to keep those points in mind as you listen to this presentation. So let's get started. Hi, David.
Hi, John.
How are you?
I'm very well.
Could you introduce yourself, please?
Of course. My name is David Naughton. I'm a partner in the financial services team of LK Shields in Dublin, Ireland. I specialize in the authorization and ongoing operation of all types of investment funds across the liquidity spectrum, particularly the AIF product.
Thank you. The legislation is fairly detailed. Can you just describe what was enacted and when does it take effect?
Of course, John. So what was enacted was an amendment to the existing Investment Limited Partnership Act of 1994.
Excellent. So there's a lot to unpackage here. So we're going to just stick to some highlights. So let's go to our laundry list that we have on our presentation. Legal personality. In Delaware, a Delaware Limited Partnership has separate legal personality. What about the ILP, and what does having a separate legal personality mean, or not having it?
Indeed, John. So an ILP does not have a separate legal personality. So for example, proceedings are taken against the general partner, the GP, of the ILP and not against the ILP itself. However, John, it is important to note that the ILP has some characteristics of a separate legal personality. So for example, an ILP is not required to be dissolved by a change of GP or LP, and on the death or bankruptcy of a GP or LP, that does not dissolve the ILP.
So then it is possible then in those contexts to use a general partner, or you could advise to use one general partner for multiple ILPs rather than having separate general partners.
You could.
Okay. I mentioned in my introductory remarks the regulations that are built into this. Can you explain a little bit about the regulatory side of the new legislation?
Absolutely. So, John, I think the key point here is that an ILP is an alternative investment fund, an AIF, whose legal structure is a partnership. So that it is first an AIF and then a partnership. The ILP comes into existence when it's authorized by the Central Bank of Ireland, the CBI in short, and is then subject to a supervision regime within the legal and regulatory framework for AIFs in Ireland. To summarize then, an ILP is first an AIF and second a partnership. Of course, it's a useful method of collective investment as it provides limited liability to investors and an easy structure in which to invest and withdraw capital.
And as being an AIF subject to the AIFMD, or?
It's subject to local rules. So AIFMD comes into play in the context of the AIFM. Because the ILP is an AIF, it has to have an AIFM appointed to it. So in terms of the key service providers of an ILP, it is the AIFM, but we also need a local Ireland regulated administrator, depository, and auditor. I think it's important, because you mentioned AIFMD, John, just to focus on the AIFM very briefly. The AIFM may be authorised in Ireland or authorised in another EU member state and allowed to passport its management activities into Ireland, or it can be authorised outside the EU. But just to note, a key advantage of an authorised AIFM in Ireland is access to the marketing passport, so that the interests of the ILP can be sold into the EU market. And that's a very important structuring point for US managers to bear in mind. The general partner appoints the AIFM of the ILP and also acts in an oversight capacity. And in terms of approval timing of the ILP, typically it'll take 6 to 8 weeks to get all contracts negotiated. And then you have a 24-hour filing process with the CBI, so that if we were filing by 5 p.m. tomorrow, Friday, you would have your authorization of your ILP next Monday.
Excellent. Timing is everything. Structures. Do you anticipate, are there any limitations on the types of structures that an ILP can have? For example, like again, a Delaware limited partnership can be open-end, closed-end, can be used in a series, although they typically aren't, but yeah.
I mean, ultimately, John, what we're going to see in practice is that an ILP will be structured as a closed-ended investment fund, very much the same as if your partnership structure was in Cayman or was in Delaware. That's what we'll see in practice. Now, the ILP can be structured as an umbrella fund with multiple sub-funds housing distinct pools of assets and liabilities. And I think what we'll also see is, in the context of the ILP being an AIF, that you'll see structuring of qualifying investor AIFs, or in short, the QUAIF product. So in summary, you'll see a QUAIF ILP being structured, which is closed-ended. And I do anticipate some managers may also be interested in structuring that closed-ended QUAIF ILP as an umbrella fund.
And just to be clear for everybody, a QUAIF is for qualified investors. And generally, what are the eligibility standards to be a qualified investor?
Yeah, that is a very good question, and it is very important that that distinction is drawn. So a QUAIF ILP is one that can be marketed to professional or well-informed investors, and they have to fall into one of three categories. One, a professional investor within the meaning of MiFID. Two, an investor who receives an appraisal from, for example, a MiFID firm, that they have the appropriate level of expertise. Or three, an investor who certifies to the GP of the ILP that they are an informed investor by providing a written confirmation. So as you can see, this is very much a product that is targeted at the sophisticated investor end of the market.
And consistent, very consistent with the AIFMD. Exactly.
I might just add, John, on that point before we move on, that this accentuates the fact that this is for sophisticated investors. There is a minimum initial subscription per investor of €100,000 or its equivalent required, but there's no limit on the monetary amount of subscriptions thereafter.
Okay. Type of investment assets. So does the ILP, can it invest in just about anything, or are there any limitations?
There aren't, not when structured as a quaif ILP. The legislation does provide that the principal business of an ILP requires to be investment of its funds in real or personal property, including securities. But in reality, John, what we're going to see is the same asset classes that we see in partnerships in other jurisdictions, principally private equity, real estate, but there's full flexibility in the ILP product to invest in the full spectrum of typically illiquid asset classes.
Is there any limitation on digital assets, or is that still to be determined?
That's a really good question, and it is to be determined. We haven't seen it to date, but it is becoming more and more popular. That is the future, and because of the flexibility of this product, I have no doubt, John, when we're talking about this product in the future, you will see those types of assets housed in an ILP.
Okay. Moving to the general partner, are there eligibility requirements applicable to the general partner or its directors?
There are, John. One GP must be a corporate entity. Now, other GPs can be partnerships. However, the CBI, as the regulator, requires that each GP be a regulated financial service provider, and that's an entity effectively subject to regulation in the EU. Now, in Ireland, what does that mean in practice? In practice, you'd set up a GP in corporate form, and it would be considered to be subject to regulation on the basis that its directors are subject to a pre-approval fitness and probity standard before they can sit on the board of that GP. On that basis, that entity would be considered to be a regulated financial service provider and can be appointed as the GP of the ILP.
And may the GP board be comprised of directors who are not Irish directors?
Yes, there isn't any residency requirement there, John. So it can be a global director cohort, which can apply to seek pre-approval from the CBI to sit on that board.
One of the big issues for multi-fund offerings when you're trying to take like a Cayman product with a Delaware product and a European product is sort of the harmonization of fiduciary duties. Delaware, for example, is pretty specific that the director or the general partner has a fiduciary duty, a duty of loyalty, and a duty of care. What are the GP fiduciary duties vis-a-vis the partnership and the limited partnership for an ILP?
Yeah, no, again, a very topical point, John, a very topical question. So the reality is that the ILP Act isn't specific on this point. So we need to fall back on general partnership law principles. So the GP does owe fiduciary duties, and they typically include the duty to manage conflicts of interest, to act solely in the interests of all partners, and not to make any secret profits.
Okay, so very similar to the US rule. I'm sure the more significant differences as you sort of parse that, but as a general matter, very similar.
Yes, John.
Okay. Indemnification and exculpation of the general partner. Is there any limitations? How is that resolved as under the ILP?
Yeah, I mean, taking a step back, John, I mean, and common to other jurisdictions, the GP does take on unlimited liability for the debts and obligations of the ILP. Of course, if there's more than one GP, this liability is shared on a joint and several basis. Now, a very interesting point to note is that in the ILP Act, as amended, there is a provision which says that if, and irrespective of whether a provision on exculpation or indemnification against liability of a GP is contained in the ILP agreement or any contract with that ILP, that is deemed to be void. as a matter of law. So effectively, a GP can't carve out or exculpate itself from liability or seek that indemnity provision from the ILP. However, the amended act also does say that the ILP now may purchase and maintain insurance for the GP in respect of that type of liability.
Okay. Looking at the limited partners, presumably their liability is limited to completely to their capital investment.
Exactly, John. So the definition of a limited partner or an LP in the legislation does provide that the LP is not liable for the obligations of the ILP beyond the amount of capital contributed or undertaken to be contributed by the LP to the ILP. Now, another point to note is that the LP gains the benefit of limited liability once the ILP is authorized as an AIF by the CBI. And I think that goes back to the point that we should always consider the ILP to be an AIF first and a partnership second. And of course, the benefit is being granted to an LP on the basis that the LP is prohibited from taking part in the conduct of the business of the ILP.
Now that always raises an interesting issue for limited partners who are serving on advisory boards, especially in the private equity and the real estate space. Is there, under Delaware, there's a specific carve out for when for a limited partner, as to when they are considered being participating in the business of the partnership. If they are considered participating, then they don't get the benefits of the limitation of liability. Is that similar to the way the ILP works?
It is, John, and that is a positive development from the perspective of the LP. So in revising the legislation through the amendment bill that has just got passed by our Parliament in Ireland, the whitelist of permitted of activities of an LP, which wouldn't bring them inside the remit of being doing away with its limited liability status, acting or serving on an advisory committee of the ILP is clearly permitted as being an activity that doesn't constitute carrying out the conduct of the business of the ILP.
One issue, we're coming to capital commitments and contributions. Under for an ILP, is a investor's capital commitment, is that considered a contractual obligation, or is that considered a unpaid capital?
It's considered to be a contractual commitment, and it needs to be made or undertaken to be made by an LP at the time of entering into the ILP.
Now, in 2008, one big issue that came up with certain types of funds were unpaid capital commitments. When the fund was underwater, a lot of creditors were, claiming that, we're suing the general partner to require it to call capital. Limited partners were pushing back, claiming that this was not in the best interest of the limited partner. How does that work under the Cayman statute was amended specifically to address this issue? How does it work under the ILP?
Under the ILP, effectively, if there is a default on a capital commitment, that is deemed to be a breach of contract, John. So that is something that can be enforceable against the LP. Remedies can include a partial...
it's not considered a penalty, is it?
Actually, the statute clarifies that, John, and it does say that where an LP fails to perform any of its obligations or it breaches the ILP agreement, i.e. it doesn't, when it's called upon to do so, contribute capital, then any sanctions applicable for the failure of the performance of that contractual obligation would not, just because the LP has not performed that obligation, be considered to be penal in nature. And
Okay.
That's important because previously the courts in Ireland had determined that provisions in an agreement which have pose additional obligations on a party in the event of a breach or a default would be considered to be penal and thereby not enforceable. However, the statute as amended now clarifies that that is no longer the case.
Okay. And then going back to the rights of the GP to compel capital contributions that we talked about.
Exactly. So the GP certainly has that right. It has the right to compel those capital commitments to be paid.
Okay, and it's clear. So it's clear essentially that it can do that without necessarily exposing itself to a breach of a fiduciary duty.
Exactly, and that should and will be contained in the ILP agreement.
Okay. Multiple classes, are those possible for an ILP?
They are. Now, there's interesting developments here, John. First of all, you can have multiple classes of interest in an ILP with differing features and characteristics, for example, fees, distribution policy, etc. Now, the Central Bank of Ireland is currently consulting on some of these class structuring issues, which can give further flexibility for a closed-ended ILP. So, for example, under consultation at the moment is the ability for an ILP to issue interests at a fixed price throughout the life of a closed-ended ILP. Likewise, there is going to be the ability for a ILP to issue classes of interests which permit an LP to be excused from a specific investment. Now, just one thing to note, that if an ILP wants to gain access to that class, it will need to provide a legal opinion accepted by the AIFM and the GP as to why it needs to be excluded from a specific investment. Likewise, there is the intention for classes of shares to be allowed to be issued, which would give LPs either the ability to participate in existing and future investments of the ILP or only future investments. And then finally, and a welcome development in the industry in Ireland, the CBI will shortly be permitting the creation of carried interest or management classes. Now, just in the consultation paper, there are two principal conditions which would permit an ILP to issue carried interest or management classes. One is that the terms of the classes are set out in the ILP's prospectus, and we'll touch on the requirement for a prospectus later on, John. But secondly, and this is only a consultation at the moment, in respect of the carried interest class, the CBI's current guidance is that capital payments, either a return of contributed capital or any distributions, are allocated to investor classes in priority to the carried classes. Now, that rule isn't crystallized yet. It is under consultation. So when we next speak together, I hopefully will be in a position to give you an update as to where the regulator lands on that point.
Okay. Obligations to return distributions under the Delaware statute. A limited partner receives a distribution, it's only obligated to return it if it knew that at the time of the distribution, the partnership's liabilities exceeded its assets. Similar to the ILP, or is it different?
I mean, I suppose there's 2 points here. One is a return of capital. So an LP is invested into the ILP and it puts in a request for a return of its capital.
Yeah.
That is permitted under one well, there's a few conditions, but a condition relevant to what you just asked me, John, is the condition that the net asset value of the ILP is above zero, i.e. that the ILP is currently solvent. Now, in terms of distributions, i.e. a preferred return on the basis of an investment, that is at the discretion of the GP. Now, the distribution policy needs to be disclosed in the prospectus so that any LP knows the distribution policy in advance of an investment. However, the distribution piece is at the discretion of the GP.
Okay. Leverage, any limitations on the use of leverage by an ILP?
No, when an ILP is structured as a quaif, the beauty of that product, John, is it gives good flexibility on leverage. The key rule there is that any leverage used is subject to appropriate disclosure in the prospectus, which meets the requirements of the CBI. And just to note, and again, going back to the centrality of the AIFM in the structure, the AIFM typically will calculate or delegate the calculation and maintain compliance with the disclosed leverage limits that are in the prospectus of the ILP.
And just to reiterate that leverage is as calculated under the AIFMD. It's not the traditional ways that a lot of US managers think of leverage.
Exactly, John. So, and the rules are quite prescriptive on what is the meaning of leverage, but those rules are contained on AIFMD. They're not specific to the fund product per se. It's more because an AIFM can utilize leverage that the rules are contained in AIFMD.
Okay. What information about the ILP is publicly available? I mean, do they have to publish their financial accounts? Do they have to maintain a public list of who is a limited partner, their addresses, capital contributions? What access do other limited partners have to the information of their fellow partners?
In short, John, no real information is publicly available in respect of the ILP. And you've hit on some interesting points there. First of all, the names and addresses of the LPs and the capital contributions do need to be recorded in a register of interests, which are maintained by the GP. However, except where otherwise provided for in the ILP agreement, the register is only open to the inspection of any partner or the depository of the ILP with the consent of the GP. So it is a consent-based access for a partner or a depository. Now, of course, the regulator has a right of inspection of the register of the interests of the ILP, which is maintained by the GP. Just to note, because it is a regulated investment fund, an ILP, as authorized as a quaif, is required to file annual audited accounts with the CBI. And of course, there are those monthly and quarterly statistical returns of the ILP that are required to be filed by the CBI. Now, that's typically looked after either by the AIFM or a delegate, but just to note, the CBI is under a statutory duty of confidentiality when it receives this information, and that information does not require to be made publicly available.
Okay. We've touched on already the obligation to produce a prospectus. Anything that they should know? I mean, we also talked about, for example, in the US, the concept of a club fund, where you have the limited partners actually participating in the selection of the investment, even though they're not going to participate in the management, but they'll be heavily involved in the negotiations of the terms. You know, but as we discussed, would a prospectus be required in that kind of situation?
It would, John, and this is a difference and it's the same for any regulated fund in the EU. As part of its authorization process, an ILP must prepare and have available for publication a prospectus containing information which would be sufficient for prospective LPs to make an informed judgment of its investment. So the content of the prospectus must comply with the terms of the CBI's AIF rulebook, related guidance, and also certain requirements contained in AIFMD. Now, the reality is that typically we would work with Sullivan, because Sullivan would know the touch and feel of a prospectus that might be in existence for other products in other jurisdictions. Where we would then partner together is we would revise that prospectus, add in the key local Ireland law requirements and regulatory requirements, and then finalize that for filing with the CBI and for its noting in advance of the authorization of the ILP.
Finally, migration. You have Cayman products, Bermuda products, all sorts of products out there. Is it possible to migrate those products to an ILP?
John, it is. So a partnership from a relevant jurisdiction, which is classified as an AIF, can migrate to Ireland and continue its existence as an ILP, following a relatively straightforward procedure, which is detailed in an annex to the legislation. Now, I mentioned the term relevant jurisdiction. That is to be confirmed by the Minister for Finance as to what is a relevant jurisdiction. It's anticipated that those jurisdictions will include Bermuda, the BVI, Cayman Islands, Guernsey, and Jersey, but it does require that ministerial order. Now, just to mention that before migrating a partnership into Ireland, the promoter or sponsor must be satisfied that the partnership meets all the requirements in the legislation in relation to an ILP, and a statutory declaration will be required which confirms those elements. But once everyone's happy that it meets those requirements, then the migration can happen. And just two final points on that, please, John. One is that the migration doesn't operate to create a new legal entity, so it won't affect contracts made or rights and liabilities of the migrating partnership. That's number one. And then number two, then, that an authorization to carry on business as an ILP is automatic upon the acceptance of an application to migrate by the CBI, i.e. you're not going to get involved in a iterative review or consultation process with the CBI. Once you file, automatically then, once the letter comes out approving, you are migrated into Ireland.
And that last point is very important for managers that are trying to preserve their performance, because if you're able to continue the entity, you're able generally to continue reflecting the performance. You don't lose that prior performance, which is very important. Yeah.
Exactly. The track record on performance moves with the entity.
Good. Well, that's a lot to unpack. Thank you very much. I appreciate it.
Thank you, John.
What would a presentation now be without a discussion on tax? Brian Murphy from Grant Thornton, would you like to introduce yourself?
Thanks, John. Great to be here. And thanks, David, for some very detailed, insightful comments from a legal perspective. John, as you mentioned, I am a tax partner with Grant Thornton here in Dublin, focused very much in the financial service interest in the asset management sector.
Thanks. Earlier, we talked about an ILP as being tax transparent. Would you explain what that means and how different that is from, say, an Irish collective asset management vehicle or ICAV?
Yep, absolutely. So, John, as you know, the ICAV and indeed its predecessor, the PLC fund, are considered to be corporate structures that are not subject to tax in Ireland at the fund level. The ILP achieves a similar result, but is treated as a tax transparent investment vehicle from an Irish perspective. And as a result, the ILP is disregarded for Irish tax purposes. And again, no Irish tax will arise at the level of the partnership. This serves to prevent the possibility of double tax arising if firstly the fund and then secondly the investor are subject to a layer tax on the same income. So indeed, the investors themselves will be liable to tax as if they hold the investments directly, with the ILP being treated to be transparent.
Okay. We also referred to the ILP as being fit for purpose. Can you explain what that means and why it's important in the context of Irish funds?
Yeah, absolutely. So again, a lot of the key measures I think have been dealt with from a legal perspective in the first presentation there, John, but from a tax perspective, I'll cover some of the key attributes. So firstly, the transparent nature of the investment limited partnership allows for underlying income to retain its natural form. This is important because the investors are likely to benefit from the return being treated as a capital gain rather than income on receipt. Secondly, there's an advantage for investors that will benefit from tax treaty relief in their own right. So for example, sovereign wealth funds. In these instances, the direct line from the asset to the investor via transparent vehicle is very important and can have some critical benefits from a tax perspective. In addition, it's also attractive for tax-exempt underlying investors, such as pension funds, and again, possibly sovereign wealth funds, that do not incur taxes directly, and they do want to ensure that you don't build in an additional corporate layer to the structure that itself could give rise to taxes. And again, that point is critical because the investors themselves will not be disadvantaged by investing in a pooling vehicle. So the advantages you get from investing in a fund or indeed some sort of a pooling vehicle aren't denied to those investors. I suppose it is important, I suppose, to consider when you're thinking about tax, the pace of change in the global tax landscape in recent years in particular, because this no doubt has increased dramatically, and indeed scrutiny on same has increased dramatically. So one key point I think that is worth mentioning in respect of transparent structures, the ILP and its equivalents, is that the impact of the multilateral instrument or the MLI and the introduction of principal purpose tests, which could have some significant impact in the context of corporate structures. Well, the impact of same will be limited in transparent structures such as the investment limited partnership. Other matters do need to be considered when you're looking at a structure like this, such as the perspective of the anti-hybrid rules in various different jurisdictions and how they will be treated. So that's something which, if we're being open about, is probably something that's evolving on a jurisdiction by jurisdiction basis because of the recent introduction in some jurisdictions of those rules. But the transparent nature of the ILP probably means that it gives security around treatment from an Irish perspective and indeed from an international perspective.
And you know, coming from the US, looking at how Europeans treat limited liability companies, you know, the fact that even though in the US you can check the box that they can either be a partnership or they can be taxed as a corporation, you know, not all your jurisdictions, you know, take that same approach to that. So I could appreciate how important some of these issues are and why having a limited partnership itself, just the designation, helps clarify those issues.
Yeah, no, absolutely. Again, I suppose when we think, and I'm not going to preempt what a US tax expert will say in this regard, but certainly when I think about US investors, they're generally seeking to ensure that the fund does not incur any incremental tax, that there is a pass-through of capital gains tax treatment to the investor, or certainly the ability to have it, which is generally more beneficial than the treatment of passive income. The US investors are generally seeking the opportunity to limit the possibility of phantom profits, or effectively what I understand to be taxable profits where cash is not generated in the US at that point in time. The ILP allows to ensure that doesn't happen. And then a US investor is looking for limited tax filing obligations in the structure. The ILP certainly achieves that, certainly over and above a corporate structure. And also the ILP should seek to achieve the fact that the gains they're not generally subject to tax outside of the US. And so where gains are taxed, the structure itself will not or should not prevent credits being claimed in the US. So transparency certainly seems to help, in my experience, for all of those objectives. Yeah. You mentioned the check the box election. So again, the ILP, much like the ICAV, allows for a check the box election to be filed. And indeed, from an Irish perspective, in the first instance, the default position will be that it's a transparent entity in any event. So I think it gives a lot of flexibility. It is a very significant alternative to the ICAV, which from an Irish perspective gives you your corporate blocker where you want it. And now we have a fully functioning, we'll call it, investment limited partnership structure that will have an awful lot of merits that the ICAV will have, but from my perspective and from a tax perspective, achieves the tax transparency in a much clearer manner.
Okay. Great. Thank you very much. Michael Humphreys, we now come to distribution. Michael?
Yes, hi, John.
Hi.
Thanks for that.
Would you like to introduce yourself, please?
Thanks, John. My name is Michael Humphreys, and I'm a director at Davy in London. Davy is a large Irish asset and wealth manager. We're about 90 years old, and we have about 700 employees, and we're based in Ireland, in the UK, and in Luxembourg. We have a number of businesses, including asset management, wealth management, corporate finance, and capital markets businesses. And the part of the business that I sit in is Davy Global Fund Management, or DGFM.
Well, as we all know, you can have a great investment strategy and a great track record, but at the end of the day, you need to sell your strategies to investors. How do you see the ILP fitting into an investment manager's European distribution strategy, as well as their global distribution strategy?
Yeah, absolutely, John. So there's a couple of key points, I think, here. One is that, you know, this amended legislation really makes the ILP a great option for US managers wanting to raise capital in Europe and wanting an Irish vehicle to do that. So it really brings the existing ILP forward in terms of how it operates and some of the points that David mentioned earlier. So it's a modern limited partnership structure now available in Ireland to US managers. And I talked to a lot of US and other non-European managers in terms of, you know, how to adapt their strategies and how to bring their strategies to European investors, usually to institutional investors in Europe. And I think the ILP will be a great option for those people. The second kind of really important point is that, it's a point that David mentioned earlier as well, is that the ILP benefits from what's called the AIFMD marketing passport. And AIFMD, as many of the US asset managers listening will probably already be aware, is a directive that was enacted in Europe a number of years ago, back in 2013, and it covers all alternative investment funds in Europe. And it contains a marketing passport, which is extremely useful. It allows an AIF that's established in Europe, for example, an ILP, to register itself for distribution across Europe in whatever jurisdictions you want. And that's a sort of a register once, sell everywhere type of mechanism. And it's quite different from the previous system that US asset managers would have used, which would be local national private placement regimes. I'll talk a little bit about the differences between those two in a moment. But I think a key point is that, you know, the ILP benefits from that European-wide system of marketing passport in the same way as an AIF anywhere else in Europe or any other type of AIF established in Europe would benefit, and that's a big advantage.
So in other words, you would have the ability to, an ILP would be able to sort of slide into any other products that you manager may have in Europe. In other words, it could run parallel to it. You don't need a lot of additional infrastructure to support it. Correct,
exactly. And there are several different ways of integrating an ILP into a global strategy. A large US or other global asset manager will often have, for example, a US fund that may be running for several years, and they may have other funds where they bring in investors from different parts of the world. And I'll talk in a moment about how you actually integrate an ILP as part of that strategy. I'll just briefly touch on probably a lot of the listeners will be familiar with the national private placement regimes, but one of the big advantages, I suppose, just to touch on this, is that the national private placement regimes are a bit of a patchwork. So they're good in some countries, not good in other countries, not available at all in other countries. And there's sort of a trend to make them a little bit more restrictive over time. So it's a little difficult to rely on them. They can work for managers with a specific target market where those private placement regimes are good, but they're not an all-encompassing solution for the entire of Europe. They also do require liaising with local legal firms to ensure that you're complying with the up-to-date rules and keeping on top of changing rules in national private placement regimes. And one of the big advantages of the marketing passport is all of that is really replaced by a single authorization. And the way it actually works is that the AIFM of the fund, which David referred to earlier, which is a key role, that AIFM, which could, for example, be an Irish firm, either established by the asset manager themselves or outsourced to a third party who can provide that sort of AIFM services. Davy, for example, that's one of the things we do for our fund clients. That AIFM makes a registration in their home jurisdiction, so to the Central Bank of Ireland, and essentially 20 business days after that registration or earlier, you have approval to market in the jurisdictions you want, which could be the entire of Europe if that's what you wish. Although it's 20 business days as set out in AIFMD, in our experience, the approval can come through from the Central Bank of Ireland in as little as a couple of days, less than a week. So that's a very efficient process. And I'll just very briefly touch on reverse solicitation, which obviously many of the US asset managers would also be familiar with. Reverse solicitation isn't really a marketing strategy because it carries significant risks relating to regulatory sanction or even claims by investors. So that's quite an unhelpful market. It's not really a marketing strategy at all. It is a good strategy if there are genuine reverse solicitation inquiries from particular investors in particular jurisdictions. But most European regulators are now taking a more and more narrow view of what reverse solicitation really is and querying whether it really is genuine. So that's just to touch on those points, John.
Now, are there any issues with the ILP with respect to the upcoming EU pre-marketing regulations?
Yeah, sure. So the EU is doing a number of things to look at how to extend the benefits of AIFMD. And one of the things that they're looking at is harmonizing the rules on pre-marketing across Europe. And there is a new set of rules in relation to that, which are starting from August of next year onwards. And when they come into play, the different interpretations by different jurisdictions as to what pre-marketing actually means are going to be harmonized across the EU. So to explain what that means, if you set up an EU fund, for example, as an ILP, and you appoint a AIFM, a European AIFM to that fund, and you qualify, you then apply for the marketing passport, pre-marketing doesn't apply from that point onwards because you're actually marketing in accordance with the marketing passport. You have that permission. But if you want to go to market before that, for example, before the fund is formed, or at a little earlier stage, you want to test the market, test investor appetite, you need to look at the particular rules in each jurisdiction. And some jurisdictions are very helpful. They talk about, as long as you're not presenting investment-ready documents to investors, that might be fine. Other jurisdictions are more restrictive. So from August on, there'll be a single rule set around pre-marketing to institutional investors across Europe under AIFMD, which is very helpful. Now, one thing to just highlight about it, though, is that it comes with a catch, which is that if you employ a pre-marketing strategy, your AIFM will tell its home regulator the jurisdictions in which you are going to pre-market to in Europe. And if the fund then takes in investments within 18 months, those investments will be considered to have been the result of marketing. And therefore, you deny yourself the chance to, for example, say that they were as a result of a reverse solicitation. So there's a presumption that if you register for pre-marketing, any investments that come in within 18 months are actually as a result of marketing. And the way to deal with that is to register for pre-marketing, do your pre-marketing, and then when the fund is established, you register it under the marketing passport, and that closes off that point.
Kind of moving along here, we have an ILP as part of a distribution strategy. Can they be used as feeder funds or master funds?
They can indeed. There is an important point in relation to their use as a feeder fund, and we get this question in most of my discussions with US asset managers. This is a point that comes up. There is a rule under AIFMD in relation to the marketing passport that says that if the fund invests 85% or more of its assets in a single master fund, then unless certain conditions are met, you can't then rely on the marketing passport for that fund. So what you can't do is set up an ILP, feed it directly into, for example, a Delaware master partnership, and then sell the Irish ILP around Europe under the marketing passport. So that type of direct 100% feeder doesn't work. There are exemptions to it. So for example, if you hold part of the ILP's assets in direct investments and part as a feeder so that you don't breach the 85% limit, that's fine. You still have the marketing passport. You can flip it around so that you can have feeders into the European fund, into the ILP, for example. There's no problem with that. And you can then sell the ILP around Europe under the marketing passport. But a very common structure, in my experience at least, is the parallel fund structure, where the European fund holds assets in parallel with the existing US strategy. And obviously there are some aspects of that need to be managed. For example, the fair treatment of the separate pools of investors in the two fund structures, the US structure and the European structure. Deal allocation, which is probably straightforward if the two structures have exactly the same strategy. And also how to hold the investment, because not every investment is easily split between two parallel funds. But there are solutions to that as well in terms of holding vehicles that can hold assets that are jointly owned between two structures, or other types of co-ownership arrangements. So parallel fund is a good solution. And again, depending on the structure, it may work as a master fund, or it may work as a partial feeder.
Yeah, and I'll just note quickly that the issues also involve tax questions, especially if you're involving U.S. real estate in terms of trying to run a parallel fund as opposed to like a feeder fund because of the U.S. anti-stuffing rules. But very good, thank you.
I should just, John, add one comment as well on European presence and substance, which I think is really important to US asset managers. And we've touched on this a little bit, but I'll just emphasize the point, which is that, one of the key things for a US asset manager trying to target capital raising in Europe with an ILP is, to what extent do they need to put, presence in Europe? To what extent can they continue to manage the structure from the US? And the answer to that question is that an ILP can be set up with a local GP. As David said, the directors of that can be US based. There's no residency requirement for those directors. They can appoint an Irish AIFM to be the external AIFM of the fund. And that AIFM does have significant substance requirements, regulatory requirements, capital requirements that are imposed by the regulator. But that can be an external third party. And then the portfolio management of the fund can be delegated to the US asset manager, and performed where they already perform it in the US. So with that type of arrangement, the US asset manager doesn't need a physical presence in Europe, except to the extent that they employ local European-based sales team, for example, if that's what they already do. But they don't need anything to specifically support the ILP.
Okay, thank you. Finally, depository and fund administration. Philip Dempsey.
John, how are you?
Fine. Can you introduce yourself, please?
Thank you very much, John. So Philip Dempsey is my name. I work for SANNE here in Ireland. I'm the country head. And I suppose just in terms of SANNE as a firm, as an organization, we are a multi-jurisdictional business. We provide including depository and fund administration services. Our core focus is on closed-ended private fund structures and hedge funds. And we also we're located about 22 countries, including a significant presence in the US, and we have just under 2,000 employees. And as I say, we've got a full end-to-end service capability here in Ireland, which obviously in terms of the relevance is our fund administration and our depository business to support the new ILP legislation.
Okay. As David noted earlier, the ILP legislation has specific duties that fall on a depository. Would you outline what those special duties are and whether there are any special issues?
Yeah, I suppose maybe, John, it's maybe an important starting point maybe to set the scene, because from an Irish limited partnership perspective, I think the depository is definitely a new concept. It's replacing, I suppose, the role of a custodian. So it very much firmly places, its role as a key player, as a key service provider within the ecosystem of an investment limited partnership here in Ireland, and it's also a recognition of the importance that the central bank places on the depository. I suppose, for the US manager audience specifically, I suppose a depository has three kind of core functions. It obviously provides the delegate oversight for all of the parties to the partnership. It carries out cash flow monitoring, and it also then does the asset verification to make sure that all of the assets held within the partnership the title is safe and secured. I think in terms of from an Irish limited partnership perspective, it's important to note, and this also applies for the fund administration business, they have to be located, their place of business has to be within the Irish state. And that's one of the stipulations, and and that's part of the Central Bank of Ireland's rule book. It varies from jurisdiction to jurisdiction, but it must have a presence and substance based here in Ireland. And then, part of that, and it's kind of intertwined with the ILP, and you have a convergence of, I suppose, two kind of very significant regulatory regimes and changes here in Ireland, is the implementation of the specialised depository regime. So firms such as SANNE, who are specialists in the alternative closed-end fund space, are now going to be authorised by the Central Bank of Ireland to provide those depository services. So that's very much a sea change here in Ireland, and that coincides really nicely with the new ILP amendments that are coming into effect here in Ireland. I suppose then, just kind of touching on a few kind of points in terms of the ILP itself, and again, this has been covered by David, by Brian, and also Michael. But I suppose the point of an ILP, and certainly talking about from a depository perspective, is, it can work on its own in terms of a standalone structure and having it as an Irish, limited partnership. The concept of the umbrella and having sub-funds within that umbrella is actually very important, because really what that does is it makes the new ILP very much a kind of a multi-jurisdictional framework, and that kind of concept wasn't here available in Ireland before. So what it does is it effectively allows managers who've got a Lux subsidiary or a Cayman subsidiary to carry on, or a Delaware LP to carry on and continue to operate those vehicles, as they were, and then also extend their range and their remit to take advantage, from a tax, legal, regulatory framework perspective, of the new ILP in Ireland. I think that's important as well to specify the fact that, for these existing, take for an example, a Delaware LP, there is no overreach provision in the in the new ILP for a depository to start, stepping in and making kind of, I suppose, what you'd like to say, changes or trying to initiate changes without any, limited partnership consent. So it's strictly confined to the Irish limited partnership.
And just to clarify that point, the point is that when there's an amendment to the partnership agreement of an ILP's partnership agreement, the depository has to sign off on the amendment as well. It's not just the GP can't just do it by itself, even though that may be provided for under the partnership agreement.
That's correct, John. Yes, and I think the fact that as long as the limited partners' interests are not prejudiced, and I think the point is to create efficiencies within the legal, the regulatory, and the partnership agreement framework, that those changes can be initiated. By the depository in conjunction, obviously, with the general partner.
Just the other point that I was going to make on the depository that you related to what you just said is that in the US, especially for private equity, venture capital, and real estate funds and credit funds, you don't always have the obligation to have a custodian. That there are exceptions to when it has to be, the fund assets have to be held by a bank. It's limited, but a lot of real estate, private equity, and other kinds of these kind of alternative asset funds rely upon it. And it is something that is different under the ILP in the fact that it doesn't matter what kind of assets, there will always be a depository.
That's correct, yes. And I think where the custodian would come in is only if there's financial instruments that need to be held in custody. Correct. So the depository will look after, say, whether it's, title deed to property or, company title for private equity investments and so on.
Yeah.
And I think in terms of having the depository, and it's got certain, as part of this new ILP, these amendments, it's got, I suppose you want to say, 4 or 5 kind of statutory obligations or functions, and those really are to carry out the instructions of the general partner as they're set out, and that obviously in accordance with the limited partnership agreement. For any kind of transactions that are going to be initiated, that they're done in a timely manner and that the consideration is either paid or received accordingly. So that's really around the making sure that all of the execution instructions are carried out in accordance with the transaction documents. I think also it's, in terms of the income flow for partnerships, that it's applied correctly. And as per the agreements. And then I think, one of the I suppose the cornerstones of any depository, and that involves working quite closely with the administrator and also the AIFM and the other parties to the fund and the partnership, is to ensure that all of the valuation are carried out in accordance with the agreements, the partnership agreements, and that the interests at all times of the limited partners are foremost. And I suppose that, if you want to sum up what a depository is doing, is really about the ensuring the investor, the partnership protection, and making sure that at all times their interests are at the forefront of the forefront of the fund, the partnership ecosystem. Just in terms of, and probably the impact on the accounting side and the fund administration is probably a lot less, in terms of, obviously operating separate capital accounts per limited partner. The process under the new ILP is going to streamline the process around contributions and withdrawals in line with the ICAV and other Irish fund structures. Also, I think, it's been touched on, in terms of having the AIFMD framework, the partnership obviously needs to be authorized by the Central Bank of Ireland. And again, that's in line with other fund structures. And then just in terms of, I suppose the accounting side of things as well, one of the core requirements under the central bank's rules and regulations is that there is an Irish appointed fund administration company. And again, a firm like us here in SANNE in Ireland, we're regulated fully by the Central Bank of Ireland, and that's obviously a core requirement. And in terms of the accounting provisions are very much along the lines of existing structures. I suppose, again, it was touched on earlier, the GP can establish and designate, separate classes of interest with different rights conferred on the various different limited partners within the ILP. And again, that would be the role and the responsibility of the fund administrator to capture those differences. That's really it in a kind of a whistle stop kind of way, John, in terms of, I suppose, obviously SANNE operates a fund administration and a depository business here in Ireland. Our primary impacts of the new ILP will be facing towards the depository, but obviously there's considerations on both sides.
Okay, well, thank you very much, Philip.
Thank you, John.
A few final notes. As we've all noted above, there's still more work to be done. The Irish Minister for Finance must nominate when the new law will come into operation. The central bank will be updating its rule book to address special ILP matters, as well as to address matters raised by the asset classes in which ILPs are expected to invest. The central bank has also considered special licensing requirements for depositories of ILPs, as Philip just mentioned. And as Brian talked about, the tax authorities around the globe, and especially in Europe, keep pushing for greater multi-jurisdiction harmonization and tax transparency. And any new tax rules are likely to affect vehicles such as the ILP. So that concludes our presentation. We hope that you see the potential of the ILP as a modern, fit-for-purpose, tax-transparent vehicle for private equity, venture capital, real estate, infrastructure, and credit strategies. As a standalone product or as part of a multi-fund offering, and with the right AIFM depository and fund administrator as a product that can slide into your existing investment strategy arrangements. Thank you very much for your attention. We encourage you to review the accompanying presentation, and we hope that you call us if you have any question or if we may be of any assistance.